Good afternoon, everyone. My name is Nikki Reich, and I'm the legal director for the Center for Human Rights and Global Justice here at the law school, and also a current co-teacher of the Global Justice Clinic, the Human Rights Clinic here. And it's my great pleasure to be here at this JILP event and to moderate this panel, which I think will be a really rich contribution to the discussion of legal pluralism and gender justice and gender equality, particularly because we have two speakers who are going to provide perspectives from what is arguably one of the most culturally, religiously, linguistically diverse nations in the world, India, where there is a rich and lively debate around the role of legal pluralism, of customary law, of religious pluralism, and in the legal system, and the role of those customary channels versus national and uniform laws in advancing gender equality, women's rights, and equal justice for all. So I understand that you've all gotten the speakers' bios in your programs, and I don't want to waste too much of our precious time here. I'll just say a brief word about our two speakers, and then I'll turn it over to them, and then we'll have some discussion here on the panel. So first we'll be hearing from Gopika Solanki, who is an associate professor of political science at Carleton University in Canada. And her research interests include religion and politics, multiculturalism and legal pluralism, indigeneity in the law, and feminist theory. And she's going to be speaking today about the value of legal pluralism and system of shared adjudication and multiple fora for addressing civil law and family law issues in India today as a strategy for advancing gender justice. And then we're going to be hearing from Rangita da Silva de Alves, who is currently at Penn Law, where she is the inaugural director. Before there, she was the inaugural director of the Woodrow Wilson International Center on Women's Global Leadership Initiative. And she's going to be speaking about many of these same issues, but offering a perspective about the way in which pluralism should inform all lawmaking, and the role of international law, international human rights law as well, in the debate about the level at which legal change and reform and advocacy occurs to advance gender justice. So without further ado, I'll turn it over to Gopika, and then we will have a debate with the panelists and all of you, I hope. Thanks.
I also want to begin by thanking the JILP team for this opportunity and the Rubin family for making this possible. And I truly welcome the chance to share aspects of my research with this different group of scholars and students. Now, in my research, I ask, how do multi-religious states facilitate minority groups and provide gender equality within these groups at the same time? Because post-colonial societies debate over the question of who should govern the family, because states and religious groups struggle to control the family, and women's rights in the family are central to these debates. Now, two theoretical approaches approach the issue. So the society-centered approaches would argue that minorities should have the autonomy to govern the family as long as the governance is transparent, democratic, and just. State-centered approaches, on the other hand, would argue that these laws violate individual liberty and equality of women. Now, the Indian state recognizes religious family laws of majority Hindu and all minority communities, as well as a range of customary laws, and has not enacted a uniform civil code. Now, it's usually argued in the Indian context that women of all religions are denied rights under all religious laws, but Muslim women are the most discriminated against, especially under laws governing divorce and maintenance. Now, I explore this question by a different route, and I focus on the Indian state's policy of shared adjudication. The Indian state splits its adjudicative authority in governance of the family with a variety of societal agents. So as a result, in India, it's state courts, as well as caste and sect councils, doorstep law courts or informal bodies, residential committees, prayer groups, individuals, a range of actors adjudicate in the governance of marriage. Now, I focus on the interactions between these different state laws and society laws and bodies, and ask, what are the ways in which this dynamic of interaction structure both cultural pluralism and gender equality? Now, in terms of methods, I present my findings based on ethnographic research in state courts and these forums. And it would be interesting that the use of state court is rather limited. Mumbai has a population of 15.5 million people. It's a site where I conducted research. There are less than 7,500 cases filed under matrimonial remedies. They're not cases of divorce. So the rate of divorce in state courts is 0.0004. Now, let me begin by outlining my argument. Now, in contrast to the body of literature which poses group rights and gender equality as antithetical to one another, I argue that cultural pluralism and gender equality in family laws can be harmonized. The shared adjudication model creates a heterogeneous and interpenetrative legal sphere which encourages cooperation, contestations, but above all communication between the state and religious communities, within and between religious communities and wider society. Now, this in turn de-essentializes religious identities. It enhances intercultural exchange and provides spaces for gender equality. And I privilege the transformative aspects of women's collective agency as instrumental in effecting change. Now, let me illustrate this point by discussing constructions of triple talaq, a form of Islamic divorce, in different legal forums. It's been much in news in India recently, and this just to give you a glimpse of the shared adjudication in operation. Now, Muslim family law in India grants the man the right of unconditional unilateral divorce, talaq-e-biddat, also popularly referred to as triple talaq, which consists of 3 pronouncements of divorce made during a single tur menstrual cycle, clearly indicating an intention to dissolve the marriage irrevocably. So the husband has to give this, the wife has to receive this, and a sensationalized image of divorce played and replayed in India is the Muslim man saying, "I divorce you thrice," and it's divorce. Now, this form of divorce causes tremendous confusion in courts because it's difficult to prove its validity. Husbands claim they've divorced wives, wives opposite, wives claim they've been divorced, husbands opposite. So how has the Indian judiciary responded to it? The issue of validity is percolated in courts, and since 2000s, consistently, the Supreme Court and a number of state high courts have given these judgments wherein they've said that that unilateral triple divorce is valid only if it's justified, if it's pronounced following genuine reconciliation attempts and they've been unsuccessful, if it's pronounced following all procedures and pronounced in front of witnesses. So what we see here is that courts don't ban triple talaq, but they've established conditions to regulate the extent of male privilege in granting divorce. Now, these reforms travel in society, and let me give you some examples. So for instance, after this judgment, a lawyer told me, and I quote, "Until now, I had fewer tools to negotiate divorce for women if a clergy delivered a divorce. But with this judgment, almost any divorce can be seen as invalid. Women have been given unprecedented leverage," end quote. Let me give you a second example. A group of Sunni Muslims living in a low-income housing in Mumbai had formed an informal committee, and they banned the practice of triple talaq. And this is what they said, and I quote, "We sought opinions from a variety of sources. We called the prominent clergy, religious leaders, lawyers, the local politicians presided over it, and we decided that we don't want to go against the religion, but this form of divorce is un-Islamic, a distortion of the Prophet's word," end quote. Let me give you a third example. I found that the Devbandis, which follow, these are religious seminaries in India, and the Devbandis follow sort of purist, sanitized Islam, and the Barelvis, who follow more syncretic, localized Islam, allow the practice. Whereas the religious sect Ahle Hadith, which is a Saudi Wahhabi sect, forbids it. Now, this variations and differences gives litigants choices. So there was this case of triple talaq that I interviewed where a man had given triple talaq and repented. And then they went to one clergy and he said, "Well, now it's valid." And then he said, "Oh, they invalidated it by converting into Ahle Hadith." So I said, "What do you mean you converted to Ahle Hadith?" He said, "No, I attend this mosque several times," right? So I said, "Have you given up attending the other mosque?" He said, "No, sometimes I go here, sometimes I go there." It's a diplomatic man. Now, how have women's organizations dealt with it? And just one example, large networks of women's organizations have initiated a campaign, and the scholars have studied it here, for model Nikahnama. Now, Nikahnama refers to the marriage contract, which is signed at the time of marriage by both the parties. It could, under Islamic law, include gender equalizing measures. So, for instance, a husband could delegate his right to divorce a wife at the time of the nikah. Now, since mid-90s, women's groups, NGOs, civic organizations, political parties have been involved in a campaign to make it compulsory. And they've failed, but the campaigns continue. In the last cause, there are emerging challenges. In 2014, a Supreme Court judgment recognized the third gender. Now, it's a broad umbrella, including a variety of cultural groups, with differing sexual and gender identity. Now, one such community are the Hijra, who follow a non-biological model of kinship, which is based on a guru-disciple mode of kinship. Now, they have heterogeneous religious identities, but all of them do worship a Hindu goddess, which is a special goddess of the transgender. Now, they are debating, should triple talaq be part of their legal tradition or not? To summarize this section and also to link it to the earlier issues of access to justice in these extremely pluralized societies requires to think not only of choices and of systemic issues of judicial accountability, but also it requires us to think of different kind of normative ideas about equality and justice and marriage and identities, a completely different way to think about procedures and systems and the way in which they operate. So for instance, state judicial system has its own form of institutional accountability, but in society it requires us to think of what are the different ways in which all of these processes could become both transparent, accountable, and I think democratization is one of the ways in which it is possible, and I'm happy to take questions. And it requires us to think of access, and as sort of earlier speakers have said so evocatively, right? It requires us to think of dynamics of interaction within that situation and think of women's choices. So what we have here is that in each, within Muslim community, what we find is each version of divorce is described as truly Islamic. And there are these different notions of Muslimness, which retains the enormous heterogeneity of the meanings of these identities. Now, what about gender equality? This model allows, in millions of micro-adjudicative sites, the sharing of women's experiences, grievances, expectations, and imaginations of law. Now, gender equality in this model is complex. It's uneven, it's negotiated, it's contingent. But it's not merely a right fixed in law. It's also open to recurrent revision, and yet there is consistently a structural movement towards change. Since independence, India's independence in 1947 to now, there has been incremental gains within family law when it comes to gender equality. Some caveats, though. I do not advocate uncritical cultural pluralism, nor do I argue that the state surrender its autonomy to society. And I do not suggest that it's only the presence of plural bodies which leads to these outcomes. There are structural conditions, and I will outline them. So my findings generally then speaks to these two theoretical approaches. So society-centered theorists, Chatterjee, Scott, and others argue for accommodation, but do not offer scope for intercultural exchanges or for de-essentializing of identities. Universalists privilege gender equality over cultural facilitation, a stance which often guarantees neither. Now, these debates are even more important in an Indian context because since 2014, the Hindu right-wing party, the BJP, has been in power. Now, for the BJP, having uniform family laws is an important tool to build a homogeneous family, which would be a foundation for a homogeneous Hindu nation. Now, at the moment, politically, it's impossible for the BJP to do so. But the push to enact a uniform civil code has recently come from the Supreme Court, and actually a judge, while giving a quite regressive interpretation of reforms in the Hindu inheritance laws, commented that you needed a uniform civil code in order to wipe out triple talaq. Now, some liberals and others argue for a set of gender-just laws. I would reiterate here that neither a uniform civil code nor a set of gender-just laws will provide gender equality. Legal reforms, as the model shows, have to take place both in state and in society by creating institutional arrangements which allows us to think of capacious modes of social solidarity, retain the idea of complex equality, and really link issues of distributive justice with diversity. Thank you.
Great. Rangita, would you like to
Yes.
speak from here?
So just before we began this panel, Professor Jose just came up to us and said no one in this room has mentioned international law as a framework of analysis so far. And I said, well, I will not disappoint him because I want to start by first thanking the indomitable Hannah, as well as all of her colleagues who have both envisioned, imagined, and put together the annual International Law Symposium led by Herbert Rubin and Justice Rose Rubin. you couldn't have chosen a better time in the history of the global women's rights discourse. You're really at an inflection point right now. As we speak, we have just begun the dawn of the new Sustainable Development Goals. Goal 5.2 calls for the ending of violence and discrimination against women and the freedom for women to live free from discrimination and violence. The Security Council Resolution 1325, which called for women's leadership at the table in designing, defining, and instrumentalizing national security as women's security, celebrated and marked their 15th anniversary and released its global study, which strengthens that call. We are also marking the 20th anniversary of the Beijing Platform for Action, which makes gender equality under law pivotal to all of its goals. And then finally, the CEDAW, the Convention on the Elimination of Discrimination Against Women, which was ratified by India in 1993, has come of age. And both General Recommendation number 30, which calls for a re-envisioned analysis of the ways in which women's personal laws, women in their families, have enormous economic consequences. The economic consequences of marriage, divorce, custody, guardianship based on inequality, gender inequality, has been recognized. So I want to look at this issue within that international law framework, but also look at Article 16 of the Convention on the Elimination of Discrimination Against Women, which states unequivocally that women have the right to decide when to marry, whether to marry, and whom to marry. It also calls for gender equality in custodial rights, guardianship rights, in divorce, and in inheritance. And I want to take a minute to pay tribute to one of India's leading women's rights lawyers who has challenged gender inequality in the personal laws, Indira Jaisin, the former Additional Solicitor General of India, who in several cases have systematically challenged discrimination in the personal laws, starting with the Mary Roy case, the Syrian Christian inheritance law, which discriminated women in favor of her brother. That was challenged in the Mary Roy case. The Geeta Hariharan case and the Vandana Shiva case challenged some of the discriminatory principles that excluded mothers from being equal guardians of their children during the lifetime of the father. So laws are constitutive and normative. And although judges and courts have come up with progressive interpretations, as we all know, judges and courts can be capricious and arbitrary. You know, there might be another ruling that might dismantle this progressive judgment. So unless we have gender equality under the law, gender equality both in de jure and de facto lawmaking, women's rights under law cannot be protected. So what I want to do now is, within that framework, look at the ways in which international women's human rights norms, both in the CEDAW as well as in what I call the intersectional conventions, the other conventions, such as the Convention on the Rights of the Child, the Convention on the Rights of Persons with Disabilities, which all form an inextricably interlinked human rights framework, can help in drafting gender equal laws. And what I call for today is plurality and heterogeneity in both the drafting and the application of those laws. So what happens when women sit at the table in drafting these laws? Now, as we know, historically, male hierarchies have drafted these laws, and women's voices have been absent from both the drafting of the laws as well as the substance of these laws. What happens when women's lived experiences shape and inform these laws? So I look at the Indian 2005 domestic violence law as a case study. Because women sat at the table, we find that women's voices help to shape the narrative of this law. And one of the ways in which women have strengthened these lawmakings, not just in India, but in the Asian region and around the world, is the way in which the term family has been reimagined. Historically and traditionally, men have imagined family in the most limited, narrow sense of those in a formal marriage. But the term family has been reimagined in an expansive manner because women sat at the table and said a family constitutes a much more expanded notion of an extended family. Those in informal cohabitation relationships, those in intimate partner relationships, those who are widowed, women who are divorced, women who are in extended family relationships, children, and in certain of the Asian laws like Malaysia, Indonesia, and Cambodia, those women who work as domestic workers but who are part of what is constituted a residence, a family residence. So this expanded notion of a family is very much now central to domestic violence lawmaking in Asia and around the world. Secondly, because women sat at the table and brought a pluralistic perspective to those laws, we find that the term violence has been given an expanded notion. So the term violence, historically, in the 1970s, when the first domestic violence law was drafted, was seen only narrowly in terms of physical violence. So for in China, you had to prove that you have severed an arm or been blinded in order to prove that violence has been, that you have been violated. So because women sat at the table, women's experiences of lived violence has helped to shape these laws. So psychological, economic, emotional violence has now been brought into that concept of what constitutes violence. And one of the ways, and I think which is very telling, is that because women sat at the table, and women like Vrinda and Indira were architects of the domestic violence law, psychological violence was defined to include abuse that women suffer because of their inability to give birth to a boy child. Now, because women sat at the table and their stories, their narratives were heard, and because men lent in too, not just women, but men lent in too to hear those voices, you find that those narratives of lived experiences of women shape those laws. And then finally, what I want to do is to look at ways in which some of the remedies to women who are survivors of violence have been envisioned and imagined because women have brought a heterogeneous and pluralistic perspective to bear on the ways in which domestic violence laws need to be implemented. So historically, domestic violence laws were thought only in the realm of prosecution, of punishment. But now the 4 Ps have come to dominate the new generation of domestic violence laws. And international conventions, regional conventions, the regional convention, the Istanbul Convention, which is the latest regional convention drafted by the European Union, calls for the 4 Ps, that is prosecution, prevention, protection, and participation. Participation of women in the implementation of the laws, in the enforcement of the laws, and participation and the reinstatement of all women who are survivors of violence. So you see how, because of much more pluralistic notions of what constitutes lawmaking and implementation of laws was envisioned, because women, and again, I don't think of a woman or gender in a narrow monolithic sense of what it means, but in its most in its full richness and diversity. So woman is not just defined by her gender, but by her race, ethnicity, social status, and sexual identity. So because women from these diverse groups sat at the table and brought a plural voice to bear on the lawmaking and on the enforcement mechanisms, issues such as how do we get women to participate in society in drafting these laws and reinstate women survivors of violence into society, including in employment, including in social life, including in inheritance laws, was brought to the agenda. So finally, what I want to say is that none of these laws exist in a vacuum. These personal laws cannot be seen isolated from the rule of law, from gender equality under law. Customs cannot trump human rights. And I think one of my colleagues in the first panels said that the Lancaster House style of drafting constitutions has resulted in a very narrow constitutional provisions in different parts of Africa. And that is why women in Tunisia, in drafting their constitution, eschewed that narrow constitution process. And women sat at the table from the grassroots to the national assemblies. And when they drafted the provision, they looked at the Constitution of Kenya, which really reconciles customs and gender equality and states very clearly that customs shall prevail only so far as they do not violate human rights. And that language was brought to bear on the Tunisian constitution. When men drafted it, they said very clearly, customs shall prevail and customs have supreme authority over the national constitution. But when women sat at the table, they reversed that and said, customs shall not trump human rights. They will only prevail so far as they do not violate the human rights of women. And so, yes, we can reconcile customs and gender equality, but only if we use the international human rights framework as our analytical tool. Thank you.
Great. Well, I want to thank you both for framing the debate, I think, in a very useful way. And I wanted to ask you actually a couple questions digging into those last points that you just made to hopefully elicit some engagement from all of you in the audience as well. So on the one hand, not to over-polarize or create a binary that isn't there, I recognize both of you have been discussing the need for not only pluralism in the creation of state laws and constitutions and in institution building at the state level, but also for a plurality of non-state institutions and channels through which law is made and enforced as well. But I guess I wanted to hear your response a bit, Gopika, about what you perceive to be the limitations of pursuing a strategy that privileges or prioritizes pluralism in lawmaking, in strengthening the gender justness of state laws. And I didn't hear you to be saying there is no role for gender just state laws, but that you think that role is very limited, and you illustrated that a bit through the different ways in which even a just court decision is either seen as leverage or is ignored. And I also wanted to ask you a bit more about whether that same pluralism and role of women's engagement and gendered perspective is at play in the non-state institutions that you talked about. So you referred to a number of local community level, religious-based and other fora for the creation of law and systems of justice. And I'm wondering whether the push for a pluralist approach to the creation of norms in the form of state laws or others is evident in those other spaces outside of the state. So we'll start there and then maybe hear from both of you and then turn to some of the questions about what role international human rights law is playing in the discourse and the debates within India.
So the first question is, why not uniform laws? If you could, in an ideal world, have uniform laws which are gender just, why would you need legal pluralism? Why is there this need to sort of go to plural sources and and excavate gender equality. One, that if we were to look at, let's say, since we are talking about family law, I invite you to look at the reality of India, right? Just look at the economic reality of India and imagine that it's possible to construct a set of gender just laws and they will trump all cultural pluralism. 30% of India will move into the middle class, which means that from now on, 265 million people in 2014 will have incomes which are higher than $5,000 a year, right? And that is the Indian middle class. You have 32% of Indian by any standards who live under the poverty line, so they earn $1.15 dollars a day. Now imagine a gender just laws which creates, the minute you have gender just laws, you will create a normative family. Imagine what is your normative family. One idea of a normative family would be, say, husband is the breadwinner, wife the homemaker. You will be able to provide maintenance for this family, a middle class family, where it's quite possible that there is enough resources for them to pay maintenance. Think of the peasant families. The man gets an income for 10 days a month, right? There is not enough subsistence for the man to pay maintenance to anyone. So having, in these situations, is often an extremely contextualized, individual, dynamic form of justice works. In a country wherein People's Linguistic Survey of India puts 780 living languages in India, with this kind of income disparity, this kind of religious and sectarian disparities, to think that there would be one family, and this is the family, will never actually encompass the distributive justice in family law. So forget all of these ideas about what is recognition, what is not. Secondly, there have been tried, as you quite rightly point out, that judges vary. Some judges would favor uniform civil code, other won't. Now the judges in 2010 said that there should be uniform law for registration of marriage. Mind you, there is no federal law on registration of marriage. And mind you, there is no list which obviously gives you the idea about divorces in society. The legislature looked at it, 10 states tried it. In fact, they consolidated inequality in making compulsory registration of marriage. And then it completely failed, because for some people, marriage is a status. You either married or not. For others, it's an event. There are people who sort of start living together when they're 20 and they marry in the 60s when they have money to celebrate marriage. So in a country with this kind of disparity, to think about having one set of law which norms one family and has one system is actually counterproductive. So that is my answer as far as distributive justice is concerned. Secondly, that cultural pluralism, perhaps because these are post-colonial states and they're permeable. When is the best optimizing of gender equality in religious law? When state-led reforms and society-led reforms sort of tally. I'm not suggesting even for a minute that the shared adjudication model is the only way in which reforms take place. If we look at it, India has had religious and customary laws all these years, and yet there has been incremental gender equality in every religious family laws, sometimes through legislative means, sometimes through adjudication. This shared adjudication model is only limited to governance of marriage, because marriage in extremely poor society is not always about distribution of resources, it's about many other things. So that is one. So the third, and I really wanted to link it up to Rangita's presentation, that this, one of the ways in which feminists and others have plugged loopholes in religious family laws is by creating parallel civil laws. So yes, if religious laws did not give rights, it was through the shared adjudication model. It's because women's organizations adjudicated in matters of divorce, they realized that, wait a minute, when there is a case of domestic violence, what women need is shelter, and there is no right to residence in religious family laws. And then they started turning to, as I've pointed out, they've turned first to the Family Courts Act and linked up Mumbai's tenancy laws in order to create right to residence through what we call a piecemeal approach to law. I mean, this is what is feminists used to call it mix and match of law. Then all of these experimentations in order to sort of expand rights within the families were aggregated, and women's organizations in India have debated the Domestic Violence Act since 1980s. There have been drafts and drafts and drafts, and in 2005 it was enacted. So what India has several ways in which these inequalities are plugged, some through legislative action. In even in a culturally plural system, there are enough sort of civil parallel laws. So for instance, religious laws mandate child marriage, but child marriage is prohibited in civil, under criminal laws, right? So there are different ways in which inequalities are curtailed. What I'm arguing for is that in a complex heterogeneous society, what we need are what I call a bundle of strategies. It's not going to be one law for all, not one strategy for all. What we need is a bundle of strategies in order to plug equalities. And the third, it's precisely because you cannot always rely on judges that you need to create spaces in societies. Imagine in India, and let's say an ethnicized state rules over India. If you have places in societies which are secularizing spaces, it's going to be able to generate voices. You always need this tension, and I call it centralization and decentralization of law. Post-colonial states, they are corrupt, they're coercive, they're violent, they may work in some instances, they do not work in some instances. In order to give and concentrate power in the hands of what are called as political scientists, we would call them completely overdeveloped post-colonial states. It is actually to invite gender inequality. So I would think that any such amount would be counterproductive.
So, yes, so I agree with Gopika that we need multiple strategies and a multiplicity of ways in which we look at these issues. But I come from a standpoint that believes that there has to be a state accountability and state commitment to gender equality under law. And due diligence by the state means that even when the state is not directly responsible for gender discrimination or violence against women, that the state is responsible for inaction. That is what due diligence means. And the due diligence principle is now writ large in international human rights laws, and it must apply to the Indian state too, that the Indian state is responsible for gender discrimination, even when it does not directly take action, but for inaction. So why am I such a missionary for laws and for the application of the Convention on the Elimination of Discrimination Against Women? So there is now statistical data to show that countries that have adopted violence against women laws really see a reduction in violence. Even those of us who are skeptical about laws and think that unless practices are changed, laws really have very little impact. But what the World Bank has, through evidence-based research, revealed is that there's a 7% chance, 7% lowering of the chance that women will face violence during their lifetime in countries that have adopted some sort of violence against women laws. And there are 78 countries right now that have adopted and drafted violence against women laws. And you'll be shocked to know that 40 years ago, in 1974, there was just one country that boasted a domestic violence law. And countries that have ratified the CEDAW, evidence-based research shows that within 8 years have drafted a bundle of laws that protect women's rights. In India, it took 12 years. In 2005, India promulgated the Violence Against Women law. But generally, on average, it takes about 8 years from the point of ratification for a state to bring its laws in compliance with the Convention on the Elimination of Discrimination Against Women. So these laws, I think, do have impact on women. They are both normative and constitutive, but they also have concrete impact on women. And then as far as family laws are concerned, most of these plural legal systems impact family laws. And family laws have the most intimate and powerful impact on women. Women's lives are shaped and informed by family laws. No other law can have as much impact on a woman's life as a family law. That is why a family law is so central to this. We're not talking of, women in the abstract and pluralism and pluralistic legal frameworks in the abstract. We are talking of a woman's right to marry, a woman's right to guardianship, a woman's right to divorce, a woman's right to inherit property, and a woman's right to the freedom of movement, where to live, where to reside, and whether or not she can have free access to employment and economic participation. So we're really talking of very fundamental human agency issues. And when that is controlled by customs, and again, I want to refer to one of the earlier panelists whose quote I think Hannah mentioned, customs are dynamic. They're not immutable. They are shape-shifting and evolve over time. And that evolution should be done in consistence with human rights principles. And that is really the true test of civilization and of a human society.
So on that note, I guess one continual debate in society at large, the global society, if I can refer to such an entity, is really this tension around the primacy of human rights law and the notion of, and the relationship between global universal norms or standards and more local custom-specific laws and norms. And so I guess in response, Gopika, to the notion that there should be, as you've said, in complex heterogeneous societies, a bundle of laws, what place and what role is there for a standard minimum, a minimum standard or a universal norm? And more to both of you, what role do you think you've seen in your research and in your experience that the notion of these universal norms or international trans-cultural norms, if such a thing exists, has played in local discourse? Is there uptake of that locally? Is that reflected? What are groups relying on and pushing for changes? And where, if any place, do you see for that minimum standard across? So maybe I'll flip the order and give Rangita a moment to respond first.
So I'm delighted that we have Virinda, who is going to actually conclude this evening. She is one of India's best-known women's human rights lawyers, and I think her work, as well as the work of Indira Jaisingh's, really showcases the ways in which human rights norms have been translated into litigation and integrated into their legal practice in very creative ways, as ways to interpret the laws, to fill as interpretive tools. Human rights norms have been used as interpretive tools to fill a gap in the law, and ways to enlarge the laws when none existed. So in cases like the Visakha case, the famous case that for the first time established sexual violence, sexual harassment as a violence against women, because there was no sexual harassment law in India, lawyers, women's rights lawyers, innovated this new strategy that helped to translate international human rights norms into their litigation, to say that there was a course of action based on the fact that India had ratified the Convention on the Elimination of Discrimination Against Women. So the supremacy of human rights norms has been really showcased in the Indian case study. And I think the Indian case study is really one of those case studies that has now had resonance both in other parts of South Asia and in the world. As Indira Jaisingh has said, these are cross-border. Laws have cross-border impact. So a law that is developed in India has enormous resonance in other parts of the world. So although we are talking of Mexico and Nigeria and India, we're really talking of ways in which these laws have a life of their own, and these ideas travel across jurisdictions. And I'm so glad that Hannah and her team and NYU really brought these different plural legal systems as not just case studies, but a way to showcase and distill the ways in which human rights norms can be applied domestically.
Thank you. Thanks. I completely agree that the international laws and human rights norms have to be translated into state action and state policies, right? And they are translated, and as I said, the child marriage has been sort of prohibited in Indian law it's also through the influences of all of these norms. There are also international laws, and norms are also part of social movements. There are just multiplicity of social movements in India. Many of them refer to international laws and norms, and they influence processes of shared adjudication within society. What I'm challenging is this complete idea that custom only means gender inequality and human rights mean gender equality, right? Custom can also mean gender equality. And I have done this really interesting case study of a group in Mumbai which come from the lowest strata of strategy, which has completely democratized its legal system. So it went through these discussing reforms in a democratic process. Women were part of the processes, and they arrived at their own laws, which gave women far more rights than any state law did. India has had traditions of matriliny, right? Revival of matriliny is another way of going about it. I'm challenging these really sort of simplistic binaries, state versus society, legal versus illegal, custom versus human rights. They don't necessarily exist in a very sort of, in a post-colonial societies, right? And therefore, we have to work at both of these. And the third question, right, that this question that if there are these plural legal orders, then what about the sort of idea of the states? Shouldn't state exercise monopoly over violence? Yes, ideally. And I really want to point out that while, it is through neoliberalism, and I think there was a question on neoliberalism, that neoliberal reforms in India have also sort of given rise to inequalities, they've given rise to chronic capitalism, and have generated different forms of violence. So all of these sort of state hegemony to violence is challenged in the society by a variety of factors. It's not only through plural legal orders. And finally, also this question on uniform civil code, right? This idea that shouldn't we need, which is sort of germinates from your thought, that don't we need a natural, don't we need sort of common shared consensus in order to build a political community, right? Now, this whole idea of national unity in multinational states itself is an interesting idea, because as post-colonial states are not nation states, they were not homogeneous nations who became states. They are, as political scientists have argued, they are state nations. You have these bunch of plural nationalities, and then the task of the post-colonial state is to build the state, ensure social cohesion, provide economic development, and rule of law. India has adopted a multinational model where there are multiple sort of nations which are recognized within the constitutions. India practices federalism. It has extensive multicultural policies. Multicultural policies actually have not yielded to national disunity. They've contributed to national unity. A largest study done in India was found that Indians actually negotiate their national identities along with all of their particularistic identities, regional, region, caste, and they don't necessarily see a conflict between their overarching national identities and their other identities. So there are also different ways in which we think of social solidarity. I'm sorry, I'm just going to talk about secularism, right? What I'm talking about is that the shared adjudication model provides opportunity for secularizing in society, right? As Hawa has also pointed out, Professor Ndula has pointed out, that there are different ways in which you institutionalize secularism in your constitution. What this does is it is fragmenting moral sovereignty. Neither the state nor religion is sovereign. What it's doing is it's inserting the civic, the social, and everything else into the model of sovereignty in governing the family. This is a classic example of secularization from below in spaces which are required to create a counter-hegemonic narrative to the Hindu right, which is a constant challenge. So we also have to think of societal solutions in thinking about time, and they are consistent with human rights approaches.
I want to very quickly respond to
Then
this.
I'm going to open it up after you.
In India and around the world, women have been sacrificed at the altar of their family's traditions. So I'm not speaking of this in an abstraction. This is real lived experiences of women who have been victims of either traditions or customs that have violated their human integrity. And for most parts, these customs have been carried out in the realm of the private. And for long, because international law created this artificial dichotomy between the private and the public, customs and traditional practices were considered those that were not to be in any way addressed by either international laws or by national laws. So that is my fear, that your construct would in some way threaten the integrity of women's security.
Okay, on that controversial potential debate note, let's open the floor, and I would love to take a few questions or comments for the panelists or contributions from those of you in the audience to this debate. Don't be shy. Anyone? Silence in the face of a lot of insightful comments. Well, I will come back and ask a question about this study that you cited earlier about the adoption of laws on violence against women and how that is correlated with, at least by these studies, a reduction in the likelihood of such violence. And this goes to a broader question around the chicken and egg question about whether the adoption of such laws is a reflection of trends in social movements and in the state institutions or in society that already would predispose that society to have a reduction in violence, or whether it's the adoption of those laws and then the potentially pluralistic ways in which they are being enforced or exist in a dialogue with other social institutions that you're seeing change. So I guess I would be interested to know whether you think, looking at the experience of India and the adoption of the law in 2005, whether you think the tipping point and the bulk of the change preceded or succeeded the adoption of that law. Have you seen more activity? Where do you fall in that spectrum of debate about whether laws are a reflection of change made or are the change agents? If of course, there's some of both, but I'd be curious to how that plays out.
Right. So as far as India is concerned, this recently released study by Berkeley, Access to Justice for Women, shows that there has been a spike in prosecutions of gender-based crimes. After not just the 2005 law, but after the 2013 amendment to the criminal law, which criminalized rape, but still leaves out marital rape and still leaves out rape by the armed forces. So still, that has now been addressed. Okay, but that was for a while a contested issue. So laws do help to propel social change, but as we know, in the aftermath of the Nirbhaya case, it was that horrific attack that then was followed by galvanizing of the women's movement and other social movements that helped to revise the criminal law. So I think you're right. I mean, these are complementary forces, and I don't think you can unpack them. But lawmaking, I think, is central. I often say the process of lawmaking is more powerful than the law itself, because it really mobilizes different social groups and unifies the women's movement in ways that it could not have if not for that process-driven initiative.
I know you might have a response. I want to take a question from the floor and integrate that response into it so we can diversify the voices in this conversation. Thanks. I don't know if there's a mic or...
Mine is more of a comment on the discussion of custom. I think that we have the human rights instruments, which I think we have to get there, but the process, of course, is going to take a while. But I think that we have to be careful about condemning all custom, like its opposite.
Mm-hmm.
Rather than rushing to individualization of property, because this is, the kind of common law concept. And I think Uslan also has done work on Kenya, where actually it was shown that similarly, this community, they were using all these titles, and the heads of household, all the land were not with men. And the men actually led to nutritional problems, because the men were now growing cash crops, coffee, flowers, and the women were growing food, and this wasn't happening.
great. Thank you for that. Gopika.
So, and thank you for that, and I will be able to tie up. And I completely agree with you in the sense that, yes, I mean, I think if we were to look at the trajectory of lawmaking in India, especially when it comes to women's rights and personal laws both, if you look at the first phase of laws were sort of elite-driven. So it was essentially really state-elite interactions which structured it. But from post-1970s, when the Indian women's movement really grew to be a really dynamic force influencing almost all spheres of life, post-1980s, this has changed. And then really lawmaking has also happened from bottom up, from some amalgamation of international human rights laws, social movements and their ideas of justice, women's mobilizing, and religious groups mobilizing. So in a sense, that as Indian democracy sort of took root and expanded and democratized further, and which happened through post-70s and 80s, it has also led to sort of inclusion of democratic voices and of subaltern voices within decision making. So my sort of answer to your question is both. That at certain phase, maybe there is sort of elite-led sort of infiltration of human rights, but then sometimes they just take root and then there is sort of a process from within. And I completely agree with democratization of custom, which is essentially what I've found, and also in my new research on indigenous rights, I'm constantly, I find that democracy and democratizations are really important sort of variables which structure societal forums, which democratize custom. So we talked about accountability in societal legal forums, and as I've said, that there are groups which democratically arrive at consensus over their laws. And it's really, internal democracy within the community. It reflects in the way in which they form their customary laws, and it also reflects on the way in which the societal adjudicative forums are held accountable as sort of to the constituents they serve. So it is an important variable in changing custom towards betterment of women.
So my problem is not with customs, but customs that subordinate women. And I think we need to make sure that we make that distinction. And customs that sometimes masquerade as having positive impact on women, such as creating overprotection of women, can be extremely harmful. And that's why the CEDAW in Article 5 really revolutionized international human rights norms and laws by calling for the addressing of stereotypes, gender stereotypes, and customs and traditions that not only violate women's human rights, but undermine and threaten women's equal participation in public life. So customs that might on the face seem harmless might really result in having a disproportionate impact on women, such as the overprotection of women, such as the ways in which there are unequal retirement practices which stem from the tradition of women are the caregivers of their families and therefore need to retire ahead of their men, or women are the weaker sex and therefore need greater protection in the laws. So that is why we need to be very careful when we equalize customs with gender equality under law.
Any final question before we give each panelist a minute to sum up and then, please.
Gopika, this is to you. You referred repeatedly to shared adjudication. To my understanding, except for the customary laws operating in northeast of India, the examples that you took from Mumbai and from Muslim communities, none of those bodies, those groupings, actually have any authority or except for the group itself accepting it. So, even if a divorce or a maintenance order is passed, it's really up to the individual to abide by it or not, because they don't actually carry the authority. In Indian law, you do not recognize a parallel system of judiciary at all.
It's interesting, all lawyers said that to me when I went to the field. The shared adjudication model is my normative stylization of empirical realities of India. So it's in a sense a normative abstraction of, and that is the academic part of it. The second issue is that, yes, it's recognized. Section 29(2) of the Hindu Marriage Act recognizes customary divorce. As far as the Muslim personal law is concerned, as we know, it's not codified. And therefore, when we talk of religious family law in India, we mean state laws, precedents, custom, folk laws, memory, religious laws, right? And all of that. Now, all of that trickles into lower courts. It's not come to academic attention because, believe it or not, most studies, except for some scholars who are sitting here, most scholars have only looked at either Constituent Assembly debates or legislative debates or high courts and Supreme Courts. As I said, 0.0004 is the rate of divorce, and these are in lower courts. 4% of these cases go into cases of appeal. So when it comes to High Court and Supreme Court, there are very few cases, and that's one of the reasons why it's not showed up so clearly in legal records. All lower courts deal with these issues, right? Whether to recognize FUSC or not, whether to recognize different issues or not, whether to recognize customary divorce or not. So it is definitely recognized in Indian law. The courts vary in the way in which they interpret it, and that is what leads to enormous heterogeneity.
I was talking about the formations that you said, not the ones that you report.
Yeah.
Formations outside the legal system.
But if the judgments, so they're recognized at the community level, but it's also that they can get them now notarized through the notaries. So therefore the state, in fact, notaries are important sort of legal translators who translate between custom and law. And some of them also trickle into lower courts. I found these judgments all the times. And I call it a centralization and decentralization of law because judges have to sort of decide. And it's also completely living law in courts.
Great. Unfortunately, we're just about out of time. I want to give one last moment for each panelist to add something, and then we'll wrap up. Thank you.
So in my research of different legal systems, I haven't found very many traditions and customs that undermine men's rights, right? Many of the customs and the traditions that have been identified have impacted women's lives. And that is why the second generation of violence against women laws include the category of customs and traditions as a cause of action. Along with physical, psychological, and emotional, customs and traditions can also constitute violence against women. And just for one example of the ways in which sometimes we're very selective about the kinds of customs and traditions that we want to privilege. So as we know, ijtihad is a tradition that allows a more expansive reading of Sharia law. And ijtihad has been used in interpreting banking law. And that has been a very important tool in advancing Sharia law in terms of banking and finance. But when it comes to interpreting women's rights under Sharia, ijtihad's doors were closed. We're told that the doors were closed in the 19th century and therefore remain static. So you see how some of these customs and traditions are manipulated in favor of a more privileged sex. And that is why, although I celebrate customs and traditions in a way that really privileges the rights of both men and women, we need to be very careful when we are looking at customs without the lens of human rights, and especially international human rights that are universal. Thank you.
Thank you.
Thanks, and I think I just want to echo that all societies have cultures and all societies are gender unequal, and all societies have to find ways to negotiate with culture and sort of address gender inequality. And I definitely think that thinking in sort of broadly and combining issues of economic justice, of political accountability, of democratization, and international laws are useful ways to go about it. Thank you.
Great. Well, thank you. Join me in thanking our panelists.